Well, hello everybody, and welcome back to Buckle Up, It's the Law. Today, we are diving deep into the latest developments in the highly controversial Karen Reid murder case in Massachusetts. Over the past few months, there have been significant legal filings, including a motion to dismiss, new evidence disclosures, and heated arguments from both the prosecution and the defense. If you're just tuning in, this case has captivated the public's attention due to its complex details and the high stakes involved. So, grab a cup of coffee, sit back, relax, and let's break it all down. First, for those of you who may not be familiar with the case, let's do a quick recap on the Karen Reid murder trial. Karen Reid is a Massachusetts woman who was accused of second-degree murder in the death of her boyfriend, Boston police officer John O'Keefe. The prosecution alleges that Reid struck O'Keefe with her SUV during a snowstorm in January 2022 and left him to die outside a Canton home. However, Karen Reid's defense team and many Massachusetts residents have maintained her innocence, including myself, claiming that she's being framed and that O'Keefe was actually killed inside the home during a fight with the McAlberts, only to then be placed outside in the cold to stage the scene as if he was hit by a car. This case has been full of twists and turns, with both sides presenting conflicting evidence and theories. Now, let's get into the latest legal developments in the case. Let's talk about the motion to dismiss. One of the biggest developments recently was Alan Jackson and David Yannetti's renewed motion to dismiss the case. In June 2023, Karen Reid's attorneys filed a motion arguing that the prosecution has failed to provide sufficient evidence to support the charges against her. They claimed that key pieces of evidence, including forensic reports and witness statements, have been mishandled and misinterpreted. The defense has also claimed prosecutorial misconduct, whereby they accused the district attorney's office of withholding exculpatory evidence that could prove Karen Reid's innocence. Specifically, the defense are pointing to inconsistencies in the timeline of events and the lack of concrete proof linking Reid to O'Keefe's injuries, as we have seen in the previous trial last year. In response, the prosecution has vehemently denied these claims, stating that they've provided all the necessary evidence and that the case should proceed to trial in April of 2025. They argued that the defense's motion was an attempt to delay the proceedings and to simply sway public opinion. Do you buy that? A hearing on the original motion to dismiss was held back in August 2023, and the judge denied it, and the case moved to trial in April of 2024, ending in a mistrial last July. But let's talk about Auntie Bev, the presiding judge in the Karen Reid case, and her decision to grant the mistrial. First, there was clear indications that the jury had reached a consensus on at least some of the charges. The report suggests that jurors had unanimously agreed to acquit Reid on the most severe charge of second-degree murder, pointing to a lack of consensus only on the lesser charge of manslaughter. Now, if this information had been properly handled in court to begin with, a partial verdict could have been delivered on those counts where the agreement was reached by the jurors. And that never happened. The judge never looked into that. The judge never asked the jurors the question if there was a consensus on any of the charges. She simply granted a mistrial across the board. And second, the decision to declare a mistrial came so abruptly, without giving the defense an opportunity to fully understand the jury's situation. The judge, Beverly Cannoni, did not even disclose the final note from the jury to discuss whether partial verdicts could be recorded. And this lack of transparency not only has been driving the citizenry of Massachusetts insane, it could have potentially allowed for an outcome where Karen Reid would have been acquitted on some of the charges, while a mistrial would have been declared on the remaining charge. None of that happened. Karen Reid will be retried on all three. And third, legal experts have argued that Beverly might have acted too hastily in declaring the mistrial. The defense team was not even aware of the specifics of the jury's deadlock because the judge failed to share it with them, which could have led to further instructions from the court or alternative approaches like a partial verdict or a more detailed inquiry into the jury's position. Finally, the case also highlighted issues with the investigation, including the notorious conduct of lead investigator Michael Proctor, whose inappropriate comments about Reid came to light in the first trial. We have covered Michael Proctor's cross-examination on this channel previously and broke it down into its constituent parts, so feel free to use the link that is going to be in the description below to view the whole playlist. We have also done it with the McCabe's and a few others. Feel free to check it out. You will not believe some of the things that they say. Specifically, Michael Proctor's mishandling of evidence cast a shadow over the integrity not just of the investigation itself, but it might have influenced the jury's decision, and that suggested a mistrial was not the only recourse. The case could have been dismissed altogether, but that of course never happened, neither by the court nor by the prosecution. In conclusion, a mistrial in this case could have been avoided with better judicial oversight. The opportunity for a partial verdict, a more thorough deliberation, or at least a review of the investigation's conduct might have led to a different outcome, one where justice could have been more clearly served without the need to revisit the same trial. It almost feels like we're back to square one, like nothing happened last year, and that is not true, and that is not proper, and that is not correct. Thus, the handling of Karen Reid's trial raises significant questions about judicial procedures in the pursuit of justice in complex cases, especially where a judge shows clear and unapologetic bias towards the prosecution, as happened in this case. Now let's talk about some new evidence and expert testimony in the Karen Reid case. Another major development has been the introduction of new evidence and expert testimony. In July 2024, last year, the defense brought in a renowned forensic pathologist who challenged the prosecution's theory of how O'Keefe died. According to this expert, O'Keefe's injuries are consistent with being bit by a dog and are inconsistent with being struck by a vehicle, and are more likely the result of a physical altercation. The defense has also highlighted surveillance footage from nearby homes, which they claim shows no signs of Reid's SUV at the scene at the time of the alleged incident. Why? Because it never happened. They argue that this footage supports the theory that O'Keefe was killed inside the home and was later moved outside. On the other hand, the prosecution has not only rejected these claims, they have also doubled down on their own forensic evidence, including tire marks and damage to Reid's SUV, the notorious rear light, which they say aligns with the injuries sustained by O'Keefe. They've even also called into question the credibility of the defense's expert witnesses, suggesting that their analysis is biased and incomplete. To me personally, it appears like a whole bunch of nonsense, because the SUV would have had damage beyond the breaking of some mere plastic. When you strike a human being, there will be evidence that the SUV has made impact with something, a human being, etc. And there's nothing. There's absolutely no evidence of such, and the case is probably going to go to trial again in April with a brand new jury. This case has really sparked some intense public and media interest, with many taking sides based on the information available. Many of you I know also followed Turtle Boy, also known as Aiden Carney, and he has been very vocal about this case. Social media has been flooded with opinions with hashtags such as hashtag Justice for John and hashtag Free Karen Reid trending at various points during the trial last year. Some believe that Karen Reid is being unfairly targeted, while others feel that the evidence against her is overwhelming, the former being a much larger group and the latter pretty much exclusively government individuals and people linked to police. Local media outlets have been closely following every development, and the case has even garnered national attention due to its dramatic nature and the involvement of a police officer. At the end of the day, we have a dead cop. The defense has been particularly vocal in the press, using media appearances to challenge the prosecution's narrative and rally public support for Karen Reid. So what's next in the Karen Reid case? As of now, we're waiting for Auntie Bev's ruling on the new January 2025 motion to dismiss. If the case moves forward, we can expect the trial to begin as early as April 2025, where both sides will present their evidence in full once again from the beginning. All the exhibits, the witnesses, etc. Now, the trial will undoubtedly be closely watched, and its outcome could have significant implications for everyone involved, including the prosecution, the defense, and the witnesses. And don't forget about the public. And speaking of criminal offenses, do you know anyone else who might need an attorney? At Forman Associates, we know that life doesn't always go as planned. If you've been involved in a car accident or are facing criminal charges, it can feel overwhelming, but you don't have to face it alone. Our experienced team focuses on criminal defense, DUI, and car accident cases. We understand the legal system inside and out and have years of practice in litigation, both in and out of the courtroom. We have been to almost every county in Kentucky and have been admitted to practice on a temporary basis, also known as pro hac vici, in at least 10 other states and counting. We are here to fight for your rights, your freedom, and your future. With Forman Associates, you get more than just legal representation. You get a team that truly cares about you and your case. We care about your case as if it were our own and work tirelessly to ensure the best possible result for every client. If you need trusted legal guidance after a car accident or a DUI charge or some other criminal offense, call us at Forman Associates today. We like to win. While it's not uncommon for defense teams to file for a dismissal, these motions are rarely granted, especially in a courtroom with such a biased judge, which is why we like to refer to her as Auntie Bev. However, the arguments raised in the motion could set the stage for critical pretrial rulings as well as appeal in the unlikely event of a conviction. If the judge finds merit in the defense's claims about insufficient evidence or procedural errors, it could lead to significant setbacks for the prosecution. Now, unfortunately, you and I both know that Auntie Bev is never going to rule in the defense's favor on such motions, but they have to do it anyway. They have to try, they have to preserve the record on appeal. Now, some forensic evidence disputes is shaping up to be a battle of the experts. The defense and the prosecution will likely present, once again, competing forensic analyses at the trial, and the jury's going to have to weigh which narrative they find more credible. This could be a turning point in the case, as forensic evidence often carries very significant weight with jurors. Jurors believe that such evidence, and jurors are going to render a decision in accordance with what they hear. Now, the witness testimonies is another interesting part. Inconsistencies in witness testimonies and witness statements are a double-edged sword. I mean, they can create reasonable doubt, but they can also make jurors skeptical of both sides. The defense's allegations of witness tampering could further complicate matters and may lead to additional investigations or further motions. I think it is also going to be very prudent for both Alan Jackson, David Yannetti, and Liza Little to have all of the transcripts of each witness from the first trial and be ready to impeach them on any and all inconsistencies the witnesses may bring up during their second round of testimony, since their previous testimony is locked in as it was made under oath and on the record. It is a monumental task, but one that needs to be done in order to make sure that Karen Reid gets the best trial in this second round in 2025. Now, with respect to discovery, if the defense's claims about withheld evidence are substantiated, it could also open the door to sanctions against the prosecution or even a mistrial. Courts take discovery violations very seriously, as they can undermine the fairness of the trial. For example, see what happened with the Alec Baldwin case in July last year, where a prosecutor has withheld evidence from the defense and the judge ended up dismissing the case altogether based on what we like to call a Brady violation or a discovery violation. What do you think about the latest developments? Do you believe the motion to dismiss should be granted, or do you think the case should go to trial again? Let me know your thoughts in the comments below. Also, don't forget to like this video, comment below, subscribe to the channel, share this video. I want to thank you all for watching. Thank you all for being here, and I will see you all in the next video. Bye, everybody.